My name is Charles Wagner. I'm the chair of the Estates and Trusts Group from B'nai B'rith, Canada, and I wanted to welcome everyone here today to the 7th Annual CLE Seminar for Lawyers and Accountants, and I wanted to thank you for coming. As the Canadian population ages and lives longer, it appears as if the elderly have become increasingly vulnerable. The extended life expectancy increases the waiting time for potential beneficiaries, and hence the impatience of pending beneficiaries. These beneficiaries, I guess, when they have to wait, it fans the flames of impatience. This makes people, it seems, greedier. It makes them more aggressive. And it possibly has led to the unquestionable rise of fraud in our area of practice. Maybe it's because children feel entitled to their inheritance now. Maybe they just don't want to wait. Perhaps they want to protect their inheritance, and that might explain the jockeying of positions when children are fighting for who controls the money when mom and dad are alive. Who gets control of the power of attorney? Ne'er-do-wells coerce people to change their wills. Financial predators marry the elderly to secure an inheritance. Rogues take quote-unquote gifts from people who are obviously incapable. Caregivers threaten to leave the vulnerable elderly alone unless the wills are changed so that they're included. Sometimes it's subtle, sometimes it's blatant. Signatures on wills are forged. Proper wills are destroyed. If you can't find it, the previous will governs. So how do we as professionals advise our clients and protect them in the estate planning process? What do we do as accountants? What do we do as lawyers? When we're hired to litigate, what's the most effective way to prosecute or defend a fraud claim? Many of us in this room deal with these issues every day. And the speakers we've lined up today, I can tell you, I can vouch for each and every one of them. They will be giving you a seminar for you to remember for a long time. As a courtesy to our speakers, I ask that everybody turns off our cell phones. And just as a final matter of housekeeping, you're more than welcome to continue to step up and get the breakfast. This is a very informal setting. And since the food is so good, no one's going to be surprised if you do so. Each one of you has a binder. Under the binder, you'll see an index tab which will give you the schedule of presentations. The two speakers for each theme will be invited to come up here. Some of them are doing it one at a time, some are doing it as a tag team. And their presentations will be a total of 30 minutes. At the end of each presentation, there will be an opportunity for people from the audience to come up and ask questions. Where's the mic for people to speak to? Okay. Rabbi Ostreicher will demonstrate where the mic is when the time comes to be. And before, during, and after breakfast, or any time you like, you'll notice that there are 3 tables to my left, which are the sponsors table. Bank of Nova Scotia Trust Company, Wagner Sislowski and Whaley Estate Litigation, and Hull and Hull. There are 3 tables there. You're welcome to come peruse the tables and see what information you have, what swag is available that's good to take home. Our first 2 speakers are Ian Hull and Jordy Atin. Truth be told, no one needs to give an introduction to any of the speakers today. You have their profiles and their fame precedes them. First, let's talk about Ian. Ian, as many of you know, co-founded his firm with his late father, Rodney Hull, who is a mentor to many of the people here today. Ian's a prolific author. He's a great lawyer, fantastic mediator. But the truth is, there are lots of lawyers here in this room today who fit that description. So I couldn't help but wonder, why is it that Ian Hull, a lawyer from Rosedale, is the lawyer of choice for so many Jewish charitable organizations? So I asked. I spoke to a good friend of mine, Jules Cronus. Jules, you're here today, aren't you? Okay. So I spoke to Jules and I said, what is it? So he says, there are two things. First, is a Mensch. Second, hat a Yiddische Kopf. So the Mensch, we all know what that means. But to say that Ian has a Yiddische Kopf is to understand the Yiddish vernacular, that he has an intuitive genius in getting out of a pickle. So I think those skills are what helped build his office, made his father proud, and is why he is the lawyer of choice for a lot of the Jewish charities. Let's talk about Jordy for a second. Again, his profile speaks for itself, but what makes him unique, if you want to think of one word to summarize it, a mission statement for Jordy Atin, it's IWE. So what's IWE? To be clear, I'm not suggesting that Jordy is a fan of the Hamilton Tiger Cats who shouts, Oski Wee Wee. IWE is a teaching initiative that allows Jordy to make use of his legal knowledge and mentoring skills in a small environment, teaching lawyers and law clerks how to improve their practice in wills and estates. It's a very successful initiative, and if I'm not mistaken, Jordy, I think all the sessions have been sold out this year. And it really speaks to the type of professional he is, how he wants to give back to the community. So, for the next 30 minutes, I'm going to invite Jordy and Ian to come up, and we can sit back and enjoy an IWE moment.
What we thought today, Jordy and I would do is deal with the ongoing struggle. I'm on the, and I apologize for my voice, I got terrible allergies right now, so it's not that I'm dying up here with a cold, it's that dying up here with allergies. But Jordy and I were sort of talking about how we would present this and talk through this really interesting to our small-minded people in the world of estates litigation, interesting concept of fraudulent concealment. And the struggle, of course, is that I come from more of a barrister's perception of it, and I want to fan the flames of uncertainty. And Jordy is, on the solicitor side, always constantly trying to put out the flames of uncertainty. And I think fraudulent concealment does just a bit of both. Hopefully fans the flames of uncertainty a little more than fans the flames of certainty, from my perspective. But we want to spend some time sort of thinking through the concept. Jordy, before we start getting into the in-depth analysis on the cases and the development of fraudulent concealment, let's start with the sort of 101 on limitation periods, and maybe just do a brief general review of the limitation periods that we've got to consider, because fraudulent concealment, of course, is the ultimate parachute to get away from a limitation period.
Right. So, as you just said, limitation periods are something that's very scary for any practitioner, because it means that whatever claim our client may have had, how great, how strong a claim he or she may have had, it is going to fail if it is outside the limitation period. So fraudulent concealment is that great ability to get around that. So the limitation periods that I think we're going to talk about are some that are special to estates and trust practice. So there's the typical general limitation period that runs for 2 years from a cause of action. That is subject to discoverability, to the ability that is to know that you have a claim. And the general rule is that you've got 2 years from the time that you know or ought to have known that you had a claim. to bring that claim.
And so, Jordy, just from a practical standpoint, I find that obviously this is the most powerful limitation period, and no matter how much we want to dance around and talk about fraudulent concealment later, this is the one that sort of hovers over our heads, subject to the couple of the under the FLA and SLRA that we're going to talk about. From a practical standpoint, the first thing I ever in a meeting, within the first 5 minutes, I get the date of death. And I want to make sure that I've understood what parameters I'm working within, and do I have a limitation problem. 2 years from the date of death is sort of my bellwether. It's obviously oversimplifying it. We're going to talk about how we get around some of those limitation periods, but that's what I tend to do. So sorry, Jordy, let's continue on.
So that is a separate limitation period, the Trustee Act limitation period, which runs from 2 years. The first one that I mentioned was one that runs from the date of the claim. The second one is what Ian mentioned, that under the Trustee Act, Section 38, there is a 2-year limitation period from the date of death. And that section runs, because it runs from the date of death, what the Court of Appeal has said is discoverability is not an issue. We do not postpone that limitation period from 2 years from the date of death because of discoverability. Now, we'll see shortly how that limitation period is subject to fraudulent concealment, but it is not subject to discoverability.
I was probably not as clear as I should have been. I do think I go from 2 years date of death, not only thinking of the Trustee Act, but thinking of most types of claims that I'm going to have to pursue in the context of an estate matter. The date of death tends to be the starting point from my perspective. I'm going to will challenges and everything like that. I'm using that as my bellwether mark. Again, it's oversimplifying it, but you combine the Limitations Act 2-year limitation period, the general one, plus the Trustee Act. It's a good starting point, and gives you some sort of safety net. But carry on.
The other ones that I think we want to mention are some specific ones to estate litigation. The first one being the Family Law Act election, which runs 6 months from the date of death. And I think we're going to talk about how that can be affected by fraudulent concealment as well.
Sorry, Jordy, can you just break down the FLA?
Sure.
Because the limitation under the FLA is 6 months from the date of death to commence what?
To commence an application to the court for an equalization of net family property. So you take what the net family property was for one spouse, that is the deceased spouse, and take the net family property, that is basically what increase there's been during the lifetime or the marriage of the two parties. That's net family property, the increase during the marriage. And you take the deceased's net family property and the surviving spouse's net family property, and the surviving spouse has 6 months from the date of death to determine whether he or she wants to take an equalization of those two amounts, presumably only in the case where the deceased had a higher net family property. So in other words, he or she's going to receive a lump sum from the estate to equalize the two net family properties.
And what's the second step that sometimes gets overlooked and can create some exposure to us from a law pro standpoint?
So there's both the election, which has to be filed within 6 months, but also an application for equalization. So it's not enough simply to file the election within the 6 months. You also have to bring a court application within the 6 months seeking an equalization payment.
And if you're ever extending that time, I always take at least 2, sometimes 3-part order where I ask to extend the time for the application and the election right in my order because of the potentially fatal blow that if you only file the election and you haven't commenced your application, or vice versa in terms of your limitation period. Okay, Jordy, so what about the Succession Law Reform Act?
So for dependents, and that means that you are either a spouse, child, or grandchild, brother or sister, parent, that if you are being supported by the deceased, or the deceased was under a legal obligation to support you at the time of death, you are a dependent and you have the right to bring a claim within 6 months after the probate or the certificate of appointment has been issued. So that's different than the Family Law Act election, which is 6 months from the date of death. The dependent support claim has to be brought within 6 months after probate has been granted.
And the fascinating fallout from the dual wills that has been created by the Gronowski case and since is that the limitation period on the dependents' relief claims may never close if you leave open your secondary will. And it's one of these things that I'm finding more and more often. I will tell my clients, even though it's a secondary will, I will tell them to get probate of that document so I can get the limitation period rolling without leaving exposure to the potential dependents claims that are out there as against the secondary estate assets. Now that's got some controversy obviously because we've just drawn the secondary will to avoid probate tax. But at the same time, we haven't solved the problem of the limitation period running against the dependents if we haven't got probate of that document. What are your thoughts on that, Jordy?
I don't think there's a case on that yet about what is the effect of one will being probated vis-a-vis the limitation period for dependent support regarding the assets of the will that hasn't been probated. I'm not sure, to be honest with you. I would defer to your remarks on that because I don't think that the court has yet to determine that. And I mean, it would have to be a pretty significant exposure on the dependent support claim for you to go and probate the secondary will, although I can certainly see why that would be worthwhile in a situation where there was a potential dependent support claim over valuable assets of the secondary estate.
And it's difficult with bigger estates. There's a recent decision that our office is involved with. It's been released, the Jasinski decision. It was a $16 million estate, and the dependent got a little over $4 million of that estate for a 12-year relationship. So you can see the numbers start to add up. I agree with Jordy, there's no definitive answer there, but it's going to tie into our comments on fraudulent concealment, and that is that what can we do to loosen the grip of a limitation period? And this is just another issue and another consideration. I am not sure it's right in every circumstance, but it certainly brings some certainty to the exposure of a dependence claim, which is a very typically unknown quantum. And especially with large estates, the claims can be significant. So, Jordy, let's just finish up our talking about the Limitations Act generally and the other two core elements of the Limitations Act, discoverability and the 15-year rule.
The discoverability, right, that's from the date that you as the plaintiff discover that you have a cause of action or ought to have discovered that you had a cause of action. 2 years from that date is the limitation period. There's also a ultimate limitation period of 15 years from the date of the act or omission. And that means that even if you never discover it, there's a 15-year limitation period. You cannot bring a claim after 15 years after the act or omission occurred. And there are exceptions to that.
But for fraudulent concealment, which is a nice segue into this. Do people have questions at this point or comments? We can take them as we go. There's no hard and fast rules on the question side. Please.
I have a question.
Please, John.
What happens for in the cases where the estate planner, like Jordy, makes sure that there's nothing in either will, and everything's done in inter vivos trust, so you're still open to the Succession Law Reform Act? When does the limitation period start running under the SLRA?
It doesn't start right unless you go and probate the will.
But there's no will anymore because everything's
there's a will. There's still a will. There may not be any assets. So what I've done in that situation where you have, just to backtrack, there are certain assets that pass outside the estate, such as jointly held property, let's just take that as an example, or life insurance, that are subject, they're not governed by the will because they're jointly held or they're life insurance with a beneficiary designation, but yet they are subject to a claim by a dependent under what's called Section 72. There's Section 72 assets that allow you to claw back those assets into the estate. So that's a simple one. If you've got a situation where you have a potential dependent and you have only Section 72 assets, then you simply go and probate the will or get a certificate of appointment without a will if there is no will, and that will start the limitation period. And there's no estate administration tax payable because there are no assets that form part of the estate. And so that's an easy call, I think, where you've got that scenario. It's a more difficult call if you've got substantial assets that you didn't need probate for, and now you're going to have to pay probate fees on them to probate the will.
It also depends when your estate planning steps were taken. If it was sort of 5 minutes before midnight, like Stone and Stone, and the court will find a way, and they did in that Court of Appeal decision to use Fraudulent Conveyances Act to bring it back in. So it's one of these are good illustrations, and we want to just spend a few minutes now just turning to the core elements of fraudulent concealment itself. As a good litigator, I like the uncertainty that it brings, so let's start to understand it. Chuck, in his description of us speaking, highlighted the fraudulent concealment issue through the demonstration, how it was demonstrated in the Court of Appeal decision in the Trillium Health Center case. Jordy, why don't we just sort of set the stage as what is fraudulent concealment and how do we use it to our advantage to extend and elasticize limitation periods?
Fraudulent concealment, there's two points there, obviously. One is concealment. There's been, the plaintiff does not know about the cause of action. And second of all, the idea of fraudulent concealment. I want to address the fraud issue first, because it is not what we immediately think of as fraud necessarily. It is not legal fraud, it's equitable fraud. And equitable fraud requires a couple of elements. One is a special relationship between the defendant and the plaintiff. That is, between the claimant and the person against whom he or she has the claim. And so when we talk about special relationships, a couple of examples of that special relationship, trustee and beneficiary. There is some sort of relationship there that the beneficiary is entitled to rely on the trustee. And so that forms a special relationship.
The Trillium Health case was a situation where it was a doctor-patient special relationship. The other case, the Kitchen, I think it's Kitchen and Royal Air Force Association, was an employee-employer. You can see the kinds of demonstrations that the court will stretch into. If they're defining the special relationship, they'll look at it, the classic relationships for which we're all accustomed to in terms of what we would describe as special.
It's not necessarily a fiduciary relationship, but it's a special relationship. The classic ones on fraudulent concealment are parent and child, so where you see sexual abuse cases, and lawyers and clients, those as well. But of most interest to us are trustees and beneficiaries. So that special relationship, and then so the other element of the equitable fraud is excuse me, conduct which is unconscionable. For the defendant to take against the plaintiff. And it's not as unconscionable as sometimes you might think. It doesn't have to be with an improper motive. It doesn't have to be a dishonest concealment. There's no moral aspect as there is with legal fraud. Basically, it's something that's just not fair that occurred to the plaintiff. And it's trying again, because fraudulent concealment is an equitable remedy, they're looking to undo unjust or unfair results.
And there's no requirement for a positive act of concealment as well on the part of the defendant. So you can see the flexibility in the language. Now, the truth is, and we're going to spend some time now talking a little bit about the actual application of this, what is a bit of an airy-fairy concept. The truth is the courts have been reluctant to impose fraudulent concealment onto cases, and it isn't as wide of an elastic band that we would have maybe thought. When you start to look at the language, you think, boy, this is great. We've got lots of room to move here. But it doesn't always play out in the case law, and it's sort of a bit of a mixed result. So if we're looking for unconscionable thing for one to do towards the other, not looking for moral elements of it and not looking for acts of positive concealment, then let's spend some time, Jordy, just talking a little bit about how the cases have panned out.
The Supreme Court of Canada dealt with this in Gurin, and it's in the paper, which was a situation where the branch of the Indian Affairs Department they concealed the terms of a lease. And they didn't do it, the court found that it wasn't dishonest and there wasn't improper motive, but it was something that was unconscionable by the Ministry of Indian Affairs as against the Indian band because they were in that special relationship, because the Indian band was entitled to rely on the goodwill, as it were, of the ministry.
So just using that example and the other, the one that I spoke of briefly is the Trillium Health Center case, the court looked for three elements in the Trillium Health Center case to establish the fraudulent concealment. And that, in the Trillium Health Center case, that case was described aptly, as it would be the case by Charles in his opening description of us. It's a case where the patient died in 1999 as a result of complications from cancer. 2 years later, the family wrote to the hospital with questions regarding the treatment, and the hospital wrote back and told the family that the patient refused radical treatment recommendations of the doctor. Then 3 years after the patient had died, the family asked the College of Physicians and Surgeons to review and assess the treatment, and the findings weren't released again until 2003. So the patient died in 99 after inquiries by the family through two different mechanisms. The findings aren't released until 2003, well past the 2-year limitation period, and the court held that the doctrine of equitable fraud can operate to stay the limitation period because the doctor and hospital originally responded to the family was an attempt to conceal the cause of action and delay the lawsuit. So the bottom line was the courts would allow that kind of conduct to leave the hospital exposed to a claim. But the test in that was described by Justice Moldaver as the defendant and plaintiff have to be engaged in that special relationship, as we discussed. Given the special and confidential relationship of the two parties, there has to amount to an unconscionable thing to do to one another. And then thirdly, the defendant conceals the plaintiff's right of action, either actively or as a result of the manner in which the action was performed. So those are the elements that worked in the Trillium Health case. It worked in the case that Jordy just referred to with the government as well. So Jordy, let's talk a little bit about how the courts are dealing with the onus.
Right. So, and this ties in with the defense to a fraudulent concealment case. So if you are dealing with a situation where you're on for the defendant and the plaintiff is now alleging fraudulent concealment, there are a couple of defenses that we can talk about. One is the idea of onus. So just because you allege fraudulent concealment, that still means that the plaintiff who's alleging it has the burden and the onus of proving that event. And it's sort of a sliding burden or onus in the sense that depending on how bad the allegations are and how difficult it would be to prove for the plaintiff that there was concealment, the court will lessen the burden on the plaintiff. They never reverse, or the cases don't show a reversal of the onus and say, oh, defendant, you show that you didn't fraudulently conceal. They never said that. But what they do is they make it easier on the plaintiff to show fraudulent concealment and then say to the defendant, is this really what happened? And so that's how we've seen the onus work.
So the second part of the defense element to a claim of fraudulent concealment ties into discoverability. There's in our paper we've got the Ontario Court of Appeal decision dealing with the Arthurson case, and the burden is discussed there as well. But what about the obligations of the plaintiff to deal with the question of discoverability, Jordy?
The important element, obviously, is concealment. And even if you try to conceal something or something is concealed, if it was something that was discoverable with reasonable diligence by the plaintiff, then that is going to eliminate the claim of fraudulent concealment. And so the courts look at whether there was enough information out there that the plaintiff was suspicious that something was going on, and two, whether there was an active decision, as it were, by the plaintiff not to investigate, not to take any steps to determine whether they had a cause of action.
All right, I think that's sort of substantially a review of the elements of fraudulent concealment and the particular twists and turns with onus and discoverability. So we're obviously welcome any questions throughout this, but this might be a good time if anybody has any specific practical implications of it. And most microphones are up here. No one's rushing to the opportunity, so I'll turn to Jordy to continue to answer questions. Go ahead.
I want to talk a little bit about how fraudulent concealment could arise in an estates and trust practice. One of the questions that we get and that we ponder about spouses is there a duty on the executor trustee to disclose the possibility or the right of a Family Law Act election against the estate?
Or dependents relief.
Okay, let's take the easier one before we get to the harder one. You want to go ahead? Jump in. Okay. So here we have a surviving spouse who may or may not know that he or she has the right to this election or to an equalization payment. And the question is, you, as the lawyer for the executor says, well, do I have to tell the surviving spouse that he or she has this right of election? And the general consensus in my experience has been that yes, we as the lawyer for the executor trustee should be recommending to our client that the surviving spouse be notified that he or she has a potential right of election or has the right of election, and they should seek independent legal advice. If you don't do that, query whether that is fraudulent concealment. Again, it's not that there's an immoral or even a fraudulent concealment in a true sense, in a legal sense, but there's still the idea that that the spouse hasn't been told about his or her right of election.
I totally agree. I actually am a little more general and a little more vague in terms of what the advice...
Naturally you are. I've learned that from practicing with you for 14 years. A little more.
Well, because I think what I'd like to do is capture every and all rights and claims they may have. So the surviving spouse, at the opportunity when they're sitting across the table from you as a co-estate trustee, is an opportunity to say, look, as a surviving spouse, you have a very special relationship and you have special rights and claims that you may need to consider, and you need to see a lawyer, because I think capturing not just the family law rights, but the dependents relief claims as well gets covered when I've made it clear and in writing to the spouse or the surviving spouse that they have a special relationship that needs to be explored.
I would be very wary to follow your advice on this particular one. I have to agree with him, with Ian, because when you specifically point out a right that they have and they rely on you to that effect, aren't you really then opening yourself up to say, well, why didn't you tell me about further rights I may have? Right. So if you say you may have rights that you should contemplate exercising and you should seek out independent legal counsel, then you're covered. But if you say, for example, you should consider your FLA rights, what about your dependents relief rights? Right.
Okay, here's why I think there's this distinction, because I put the question to you, Chuck, and to Ian. Let's say you've got a brother out there who was maybe supported by the deceased. Are you going to go out and write a letter to them and say, by the way, you should consider your rights too? And why not tell them, tell all the grandchildren that you may have rights against this estate, and parents? Like, you're not writing to every potential dependent and saying that you may have, and put it as general and as vague as you want, you may have rights. You're not doing that. You're doing that especially to the spouse. And I'm saying to you that I don't think that there's a duty to notify potential dependents. And that's why I limited my point to spousal elections, because that is a right that the spouse has regardless. There is an absolute right to choose to elect one way or the other. In fact, they're put to that choice. There's a deemed election, but they're put to that choice. That is different, in my view, than saying to somebody who may have a claim, which requires a burden of proof and all of that, by the way, you may have a claim.
I think the only difference, and maybe it's just my understanding of the fact scenario that you're putting this to us in, is that I've got the client in front of me.
Okay,
I'm saying husband and wife dies, it's set up in a spousal trust with the accountant, the two of them are across the table from you, you're clearly being retained in the context of administering this estate, and you've got this elephant in the room that you have to deal with. I agree with you. We don't have an obligation, I don't think, to go seek out claimants per se, but when we're faced with that, and that's a fairly regular scenario when you're faced with that situation where you've got an obvious conflict. That's really it.
I agree with you in that context because that person is your client. But I'm saying in the situation where you are acting for the accountant is the executor. Yeah. And there's a surviving spouse, and one of the questions is, well, do we tell the surviving spouse that he or she has an election? They're not your client. They're in that scenario. And the general consensus in my experience is that, yes, you write a letter to that person who is not your client and advise them that they and you can draft it any way you want, but advise them that they have rights and that they should seek legal advice. And so I don't think that's the same necessarily as saying, by the way, you have dependent support claim to all other beneficiaries. Now, maybe somebody might say, some way down the road, that, look, that's fraudulent concealment. You had a duty to tell dependents to whom the deceased had an obligation to provide adequate support, to tell them about their potential claims. You're in a fiduciary relationship with them.
But there's no case that I know of.
No, there's no case.
So the question really is, are you opening yourself up as a lawyer when you do that to claims by the other beneficiaries, right, that you butted your nose in where it didn't belong, and people are, you can presume, intelligent enough to go get their own legal advice, and you opened up a can of worms? If
you've got a child who was dependent on the deceased and you know it, and you don't tell them anything, I think there is a pretty good claim for fraudulent concealment in that situation, personally. But
well, this is the nice thing about this, is that there's vague and uncertainty throughout. So we are just coming up to our 2 minutes before we run out of time and look for questions, and we can all go back and ponder how we manage this issue. But what I think is most important, the message that Jordy and I appreciate the opportunity to do, is that raising the issue is a very viable defense to a limitation period. It works in the right circumstances. It's not an onerous process to understand the concept. It's very quite naturally understandable, but there are some specific tests to it, and it is a tool that is in the arsenal for whatever side you're on. If you're on the solicitor's side and you want to protect the estate, you're looking at Jordy's view of trying to do your best you can to allow it to be eliminated and to make sure that fraudulent concealment can't raise its ugly head. And if you're on the barrister's side, you're looking for facts that will support a fraudulent concealment event. So it's added to the arsenal and added to the interesting developments.
Before we go to our next speakers, are there any questions? Why don't you come up, Brian, to the microphone?
Good morning. Just in terms of the extent of the duty of care of counsel for the estate, haven't you fulfilled your duty once you've served your notice of application for a certificate of appointment, and then the potentially dependent beneficiary is thereby put on notice, he or she has extra time because the limitation period doesn't begin to run until the certificate of appointment is issued. So if the duty extends much further, as Jordan is saying, then that opens up a can of worms, I would think, for counsel for the estate.
I'd like to address two things. First of all, anybody who knows me knows that I like to throw things out and have people think about it. So I don't know if I necessarily agree that we have that duty. I just want to, it's something to think about, is whether fraudulent concealment would apply. Two things. One, a dependent may not be a beneficiary of the estate and therefore have no notice of it. That is, you're not serving them with the application. Second of all, I'm not sure that simply letting them know that, by the way, they don't know. I mean, many lawyers don't know that the limitation period starts from the certificate of appointment. So to assume that a claimant who's dependent on the deceased knows that, by the way, my limitation period has now started because somebody's applied for probate, I don't know if that's going to get you around fraudulent concealment if you make a really good, if you've got a strong case. That would be my But I agree, it's something that you'd rely on if you're trying to defend it, but I'm not sure that would be my only argument.
And I think the current practice is that you lay in the weeds on dependents, right? You get your certificate and you lay in the weeds.
Right.
Except for the surviving spouse, which Jordy and I maybe disagree slightly on semantics, but I don't think you can lay in the weeds on a surviving spouse. But I don't chase down it. I let the clock turn, and then I say day 6 months plus a day, get that dough flowing, because it's going to be a lot harder to chase it.
And there's case law that allows the executive to do that, but I don't think anybody has ever raised the fraudulent concealment argument on this. I don't see why in the proper situation you couldn't, depending on how dependent that person was.
I'm going to end this with the last word. Just as a caution to everybody here, the red line of limitation period questions is fuzzy in the SLRA, because even though 6 months has passed, it's not like the regular limitation period under the Limitations Act, correct?
Correct.
So you can still bring an application to have that extended, but you do so at a risk, because whatever assets have already been distributed, they're gone. Thank you, gentlemen.
Thank you.